Okay, I hope we all had a nice lunch. And what is better following than talking about the AI Act? Helps with the digestion as well. And we have four very nice and enthusiastic panelists with us. Eduard, Giulia, Ian, and Nina. And I will let each one introduce themselves first and give us a sense of how they see AI Act, what made you interested in AI Act, and what's your angle. So, Eduard, please go ahead.
Yeah, hi. So you saw me before. I'm Eduard Fosch-Villaronga, and I am with Leiden University, and we are the Center for Law and Digital Technologies. And our focus on the project has been trying to make a sense of the needs assessment. We call it in this way. And in the project, we've been trying to understand, on the one side, we did desktop research on what are the legal and regulatory challenges with respect to AI in the labor market. And then we took on some stakeholder engagement activities in which we were responsible on a survey in which we tried our best to map the perceptions on the public attitudes towards AI in the labor market, focusing on discrimination and fairness. And then also we also did interviews on the topic. So a little bit like this is our angle. And also just to finish, we are also taking care of the assessment list of trustworthy AI. So that is also part on our project in which we try to assess how the tools that we are developing comply or align with the ambitions of the trustworthy AI of the European Union. So that's me for now.
Okay, good afternoon. I'm Giulia Sudano. I'm one of the co-founders and currently president of Period Think Tank. It's a feminist organization. We promote gender equity through a feminist approach to data, and we use an intersectional approach to data. So our main goal, we are a partner of the Equitas project. And our main goal, we supported basically the gathering of social requirements at the beginning of the project. And now we're engaged in the validation of the tools and the dissemination phase we will have by the end of the project in October of this year. We are very interested, as you can understand, by this small brief presentation on the issues of fairness. And I want to just underline and point out the importance for us of the equity concept, so not only focus on just non-discrimination, because we live in an unequal world for many aspects. So we really would like to get to the point where AI system and AI in general, it's used to close those gaps, not discriminate and make things worse. So that's what we will be more engaged in discussing with you today in this panel. Thank you.
Okay, I'm Ian Slesinger. I am from Trilateral Research, and I'm working on Mammoth. And I've initially got into this field through a bit of a lateral process, I guess you could say. So I started out in political geography, and I was looking at technology and geopolitical conflict. Then I moved to cybersecurity innovation and ethics and responsible innovation in that domain. And then I've moved from that into AI ethics, and particularly from a socio-technical perspective, informed by science and technology studies, which basically takes the approach that essentially there's a entwined relationship between both society and technology, and that they influence each other, and you need to look at the relationship, the dynamics between society and technology, rather than saying, either technology, produces society, or vice versa, that technology is just a, instrumental tool, because it's neither. So that's very much going to inform my approach today, which will also be from the SME perspective. And as a caveat, I am not a lawyer, so I'll probably be more concerned with the implementation rather than the specific details of the act itself.
Great. Good afternoon, everyone. My name is Nina Baranowska, and I'm with Radboud University from Nijmegen in the Netherlands. And I really hope that our panel wake you up from food coma after lunch. I have a legal background in the European Union law, and in particular, I focus on GDPR liability laws in relation to AI, and of course, nowadays on the AI Act itself. And I'm part of the FINDHR project that you have a chance to listen about today. And in FINDHR, we focus on detection and mitigation risk discrimination in AI-based ranking systems. And now the AI Act is a ground for developing AI and putting the AI systems on the market. But the AI Act does not exist in the isolation. And when we talk about AI fairness, we have to refer also to data protection law. We have to refer to non-discrimination law, both at the EU level, but also on the national levels. So far, we don't have any specific regulation on algorithmic discrimination, so we have to refer to the existing laws. And in our team, in FINDHR, we look at the relation between GDPR and non-discrimination law and now the AI Act. And we also look at the specific context, which is employment. And I think this is important also from legal perspective, because the employment context is quite, generally is quite specific, and labor market is complicated. From the legal perspective, we have a contract between two parties, but there is often visible power imbalance at the national levels, but also at the EU level. We have more regulations to protect workers' rights, but we also have some limited possibilities to process sensitive data of workers that I will talk about later. Thank you.
So thank you all for the introductions. Just to say that even though we do have a set of questions prepared that I will be asking, it's quite an open panel, so we will be very happy if some of you also would like to ask some question or also answer or give your own view. So by any means, feel free to intervene at any point just by raising your hand. So as a starting question, since I also am not a lawyer, an introduction to this topic is the AI Act is of course very wide in scope, and it spans the whole spectrum of AI systems. Specifically in terms of fairness and discriminations, what are the most relevant provisions? Eduard, would you like to?
Yeah. Yeah, actually, the funny thing about this is that actually fairness is not defined as that much in the AI Act. So perhaps instead of informative, perhaps this part of the talk is just a bit of a question on like how fairness has been put forward as such of an important principle in GDPR, for instance, but it is not that much in the AI Act. In a way, it is invoked as a normative ideal, but it is not really defined, operationalized, or enforceable as a legal principle. The AI Act embeds fairness with broader goals like non-discrimination and fundamental rights like data protection. And in that sense, similar to what Nina was saying, is that fairness must need to be pursued indirectly through obligations around bias mitigation, data quality, and human oversight, especially in AI risk categories. So in a way, it is linked to the principles of non-discrimination, and this would be like with the, well, in a way, numerous clauses list that we have, like on race, gender, disability, and age, and that already we could have a discussion on how AI is putting new ways of discrimination and how these clauses, numerous clauses list may be challenged. Then to human dignity and autonomy, transparency and accountability, and avoidance of unjustified bias. So I think that it was like a missed opportunity because the word fairness only appeared in recitals, and those that are not familiar with how the law is structured, recitals are not enforceable parts of the legislation. They are just parts that provide context to those binding principles. And when you get on the lawyer headset, you would then advise a company that that is not that much of an important rule, because of course it is not mandatory. However, like said this, I want to say that there are several articles in which this principle is called upon. One being on the prohibited practices. The AI Act works on a risk model category in which there are certain applications that are prohibited, like social scoring or manipulative AI. And the relevance to fairness is that it prevents inherently unfair or discriminatory uses. But then when it comes to risk management within the high risk category, so all of those applications that they are for the labor market, or well, I can further develop that later, but they would fall on the high risk category. The European Union has deemed such an area of a high risk to the fundamental rights of the users. So that would link to risk management, data and data governance, and then also human oversight. So just to finish with this point, on the one hand, it seems that it is a very important principle. However, it has not been that much specified in the AI Act, making us believe that it needs to be called upon in connection to other principles, but that I think that it's a bit of a missed opportunity in this respect, and that the way the AI Act is constructed, in which it classifies different AI systems in different risk categories, may be challenging in order to apply such a principle, because then, in a way, the AI Act is very explicit with respect to the obligations that each of these categories they need to fulfill. And this is also a part of a bit of a mismatch, because the idea of the regulation was more like of a product safety regulation in combination with fundamental rights. So that is why, in a way, it directs to obligations to the developers with respect to that. But I think that, in a way, this principle relates more to the users or the end users in itself. So I hope that this helps you be confused about this. I think that if you're confused, this is the whole point of my point.
Very nice. Nina?
Yeah, I can follow up with the confusion, because I really think that the AI Act is a good example why computer scientists don't like lawyers, because we talk too much, we use unclear phrases, and the answer is always it depends. And this is the case with the AI Act and fairness for me. And as Eduard made a good point, that there are some references, but mainly in the recitals that are non-binding, and preamble of the AI Act is longer than the text. Then we have the reference to the risk management systems, and here it's also very vaguely regulated. So, for example, developers should identify the known and the reasonably predictable risks of the AI system. Then developers should identify the most appropriate and targeted risk management measures. As a part of the technical documentation, they also developers should also prepare metrics and use the metrics to measure accuracy, but also metrics to detect potential discriminatory impacts. And I really like what Roberta said today, that they are trying to recommend the fairness metrics to the specific context of the AI, which I think will be super useful in that sense. And then in the main text, there is one explicitly reference to bias detection and mitigation bias but only in training, validation and testing data sets. So there is a more emphasis on the quality of the data sets. And probably, first, probably you know better than me that detecting and mitigating bias in data set, it's important, but it's not enough because even with an unbiased data sets, the AI can still discriminate. And second, it sounds a little bit, this bias detection and mitigation sounds more like a technical approach to bias in general. So it's like a compliance check. Okay, we are done with that. So then I think that's why, because as Eduard said, we don't have like a clear definition of fairness and non-discrimination in the AI Act. We have to refer to non-discrimination law that we already have, which is generally very context-specific. It's quite fragmented, like non-discrimination law in Europe, like in generally, and it's regulated both at the EU level, but also at the national levels. For example, under EU law, we have different protected characteristics depending on the sector. So in employment, we have 6 protected grounds, which is gender, age, sexual orientation, ethnicity, religion, and health. But in other sectors, for example, in insurance, there is only gender and ethnicity regulated. And non-discrimination law is quite context-specific, especially when it comes to indirect discrimination that can be justified. And as a side note, that's more for a computer science audience, I think we should be really careful with the reference to the US, because there is a lot of influence in computer science from US, but for example, in the US, they have a concept of a disparate impact, and in Europe, we have indirect discrimination, and those two concepts are not the same. So US courts, they rely more on a statistic analysis. In the employment context, they use this 80-20% rule. So for example, that the selection rate for a protected group should be at least 80% of the selection rate of the favored group. So for example, 80% women and should be included. I think that we should be careful with that, but analyzing the AI Act, we cannot forget about non-discrimination law. Thank you.
Thank you very much. That was illuminating and confusing at the same time. And you mentioned the risk-based approach and the context-dependent nature of how the AI Act should be interpreted. I'm wondering when you think about applications of AI, first of all, whether this risk-based classification is something like a holy Bible that is, we should take it for granted and correct, or whether we should try to think from time to time what are the most important applications, especially in terms of AI fairness, and in which application settings this becomes more prevalent and important. So perhaps, Giulia, would you like to say something about that?
You want to go first, Jan?
Or Jan?
Huh? You can go first.
There's a lot of religion these days, like in this presentation today, yeah?
Yeah, okay, and I'll go first. So I think before I actually try and answer this question, I need to preface it with a disclaimer, which is I think the meta lesson from this entire conference is that rather than focusing on a context as a starting point, you need to actually start from asking how do the fairness principles apply to a context, and really look at each use case in each sector individually and its specific contingencies and complexities in order to address the mitigation requirements. That said, I think a key sector in which AI fairness and discrimination are relevant, and this is actually a niche which my company works a lot in, are public sector applications, particularly where it affects public service provisions, such as sensitive data for vulnerable people, things like benefits, triaging social services, public health, areas like this. And I think obviously the most clear example of this would be the Rotterdam child benefits scandal case, which I'm sure many people in this room are going to be familiar with already. But for those who aren't, it came out in 2019, even though the system had been used since 2012 or 2013. And people were basically profiled high risk of committing benefit frauds, and then based on this identification from the system, they were ordered by the state to, they were either lost benefits and or were ordered by the state to pay back benefits and were put into debt. It led to suicides, children being put in foster care, and some other quite serious social implications, and obviously it significantly impacted social trust in both the state and in AI systems as well. And I think we need to look particularly at at why high-risk systems in the public sector are high risk. And one of the biggest factors of this is that states collect a lot of very personal, sensitive information on individuals, and individuals don't really have the right to consent or opt out of this in the way that they do with private sector, or in the way that, you know, GDPR provisions allow for in other applications. So if you're thinking things like tax data, census data, you know, data about birth registers, children going to school, right, school data, all these areas, the state collects a lot of data, and that gives them a lot of power in how to process and use that data. The second is that the significance of the scale and the scale of the decisions that the state make, particularly as they have essentially public agencies are instruments of the sovereignty of the state, so they have a degree of coercive control in decision making. And that, you know, and there's an unequal power dynamic here between the state and the individual in this regard. And finally, the third is that it's challenging sometimes to interrogate the state, including particularly because a lot of times states use obtuse processes, things like, you know, procurement processes and tenders, which are difficult to interrogate. You know, there are freedom of information request rules in many states, but then, I'm sorry because I mainly work in the UK context more than the EU context. There's definitely a UK Freedom of Information Act, but the problem is you need to know the right questions to ask in order to get that information. And the Rotterdam case, I think, is a case in point. It took 6 years since the system was even put in use for people to become aware that the system was being used, and it was being used to discriminate against them. And that was through public interest journalism, through investigative journalism that this came out. So yeah, that's my answer to that question.
Yeah, I definitely agree on what Ian said about looking at fairness in individual case specifically, and I want to point out the importance for us as all the activists that push for intersectional approach to look at you know, high risk and risk of discrimination from intersectional approach, so not just looking at bias or one discrimination at the time, you need to, you know, sum them up, and that's one of the important things, like the risk management per se. For instance, one of the important things from the gender perspective is that the gender impact assessment is not part of the methodology to do risk assessment. And for us, it's a bad news. First of all, gender impact assessment, it's a formal recognized methodology, even established by the European Institute of Gender Equality, a European institution. So, I mean, it's very well established. So we would have liked to have seen, you know, gender impact assessment in the evaluation of fundamental rights violation. And the other thing I want to point out, it's I'm going to read it exactly because to remember by heart it's not easy. There is a derogation regarding high risk. Unfortunately, most of the times, you know, there is a good principle, but then it follows the derogation to the rule, and all the things fall apart. So there are the Article 6(2)(a) foresees derogation for the use considered high risk. And these are, if the AI system is intended to perform a narrow procedural task, if the AI system is intended to improve the result of previously completed human activity, the AI system is intended to detect decision-making patterns or deviation from prior decision-making patterns, and it is not meant to replace influence or influence the previously completed human assessment. The AI system is intended to perform a preparatory task to an assessment relevant to the purpose. So this is an example. I read it quickly, sorry for that, and with my Italian accent. I apologize for that. But to show you that this list of derogation means that a lot of things cannot be considered a risk. That can be a risk for gender discrimination, for SAID1, but even other kind of discrimination, not only gender. So that's why we're very from an activist point of view, of course, we are very worried. We think that you know, the assessment, the compliance, and the role of checking all the possible discrimination that fall out of high risk are very worrying, because as you know, only the high risk cases have mandatory requirements. But if many things can fall out from high risk because of that, so for instance, there is an analysis that says a private company doing a first phase of checking for the recruitment can fall out of this high risk according to these derogations. So they're very dangerous, this kind of derogation. So we should not feel safe. We don't feel safe, that's the message, because we just have the AI Act. So I would like to point out the importance to come into play, like the AI Office, the Advisory Forum, that the AI Act foresees, in order to let them know of all the possible discrimination that can be open because of this derogation. So we need to be very active and monitoring and find ways to get together as stakeholders to outline to the Commission and the AI bodies, the European Union bodies, all the possible risk, discrimination and problems that this kind of derogation can open up.
Thank you. That leaves me with the question of whether applications that are classified as low and medium risk, are they, do you think, completely innocuous? Do you think that we don't need to worry about discrimination and fairness in such application contexts?
Are we starting with me? Or do we have a lawyer to go first? Okay, fine. I'll do it as not a lawyer. So I think, so this kind of comes around the question of what disproportionate harm is, which is the language used in the Act. And this is a question basically about how bias is defined, assessed, and mitigated. And this also comes, so I think a key issue here is the question of equity versus equality, right? This idea of equity as sort of a passive, inequity rather, as a passive harm through either negation of enabling equality by individuals. Sorry, not by individuals, for individuals, sorry. So let's say a group's discriminated against and they're not right generally, and there isn't an approach to either augment data or to enable their inclusion. That's more passive, as opposed to deliberately biased training data actively causing harm, right? So you need to make this kind of active versus passive distinction. So these require different understandings of fairness at the technical level, and as well as fairness definitions, methods of weighting them, and mitigation strategies. So that's one issue. And then another issue is questions around how high risk, quote unquote, is determined and assessed, and what falls in and out of those categories, right? And it's, so according to the AI Act, it's up to the system providers, aka the tech developers, to conduct a risk assessment and self-assess the risk category of their application. Therefore, the provider could limit functionality in the risk audit to either deliberately get around being placed in a high-risk category, or they can limit the scope of the technology to avoid it. Or there are actually, within Annex 3, there's a few kind of use cases where, so Annex 3 defines what counts as high risk, and there's specific categories, which are education, employment law, law enforcement, and justice, and I think there's a few other ones. But there's scope for exceptions within that, actually, which is defined as procedural tasks or checking activities, and to quote from Article 6, Paragraph 3 of the Act, because I'm not a lawyer, where it does not pose a significant risk of harm to the health, safety, or fundamental rights of natural persons, including by not materially influencing the outcome of decision-making. However, the mechanisms for determining the nature and extent of risks in terms of discrimination in accordance with the Act make it difficult to actually assess harms without doing an FRI, fundamental rights impact assessment, which is kind of the envisaged mechanism for implementation. We're still waiting on a template from the EU AI office on this, but it's basically based on the data protection impact assessment from GDPR loosely, and this is supposed to be how you determine specific harms and the mitigation strategies, right? And the basis for accounting for those affected by by an AI technology's fundamental rights. So there's actually almost this gap where without conducting an FRIA, you don't really know the harms. And unless you're taking a very strong precautionary principle, there's a case of unknown unknowns, right? And another aspect here is that, the sort of best, what I would say is the strongest basis is that for mitigating harm is an ethical basis, which would come from, well, initially from the high-level expert group guidelines and the ALTI framework, the assessment framework, right? From those guidelines. However, this was actually, interestingly, in an earlier version of the Act, apparently it was put as the basis for action for acting in the Act, or the basis for how systems should align. But then later on, it was reduced to sort of recommended best practice in almost an advisory capacity in Recital 27 as a voluntary best practice.
I wanted to follow up one point that you said, Giulia, like which is really touched me. That you say we don't feel safe because there is the AI Act. No, like it seems that the AI Act is not really taking seriously the fundamental rights. In a way, this sort of construction being a product safety regulation, trying to ensure innovation and being competitive, like, oh, in Europe, we are also good at doing things, and at the same time thinking, oh, but we're also good at protecting fundamental rights. But then putting this together somehow, like it didn't really convince many people. And I think that, like, also picking up like before, like when Lynette was talking, like in her presentation, that we lack like on methods. We also lack on lenses in which we are addressing some of these problems. No, I would have assumed that in being in 2024, when this was enacted, the contemporary understanding of certain concepts would be actually much more updated and progressive and modern, like in the AI Act. In a recent research that we conducted with Roger and others, like on gender classifier systems, what we see is that on the one hand, our legislation very much like puts together biological sex and gender identity as one thing. Well, traditionally, these two concepts were kind of like being together, but then our frameworks are based on that understanding. And then gender classifier systems usually work in a way that take as a parameter a binary understanding of sex, biological sex. Now, in performing some work on algorithms for social media, and we realized that there were like some what we call misgendering algorithms, basically algorithms identifying me as a female, for instance. And looking at that through much more multidisciplinary lenses, in this case it was not intersectional, but it was more like on thinking about biological sex, gender identity, sexual orientation, and gender expression, we could actually understand that discrimination was coming more from the gender expression angle, which was not as surprising because in a way, well, people are behaving online in a way that it is a little bit different than their gender, how they identify or not. So like it seems that certain behaviors, the algorithms are picking up as a more male or more female. However, what we were able to show somehow, which is appalling, is that without that lenses, you cannot catch that misclassification that in that case can lead to discrimination, no? Like, and not having these multiple lenses in which we are looking at the problems, despite having the AI Act, like, yeah, of course, you are not going to feel safe, not you, not me, not many people that are not there, and that still like shows even much more like the importance of surveying the public attitudes towards some of these responses, because it's actually in a way like these sort of external assessments, no, that from the activists, but then other communities, and so that they are capable of recognizing the impacts that these are having on those communities, no? Like, so I wanted like to know like a little bit more like on that part, Giulia, no? Like, because yes, there is like this framework, and AI Act sounds like a great step forward in establishing that framework, no? That, well, we are the first one in doing so, but it seems that it's a little bit leaving us with a bittersweet feeling, no?
Yeah, absolutely. I mean, that's why repeat a little bit what I said before, that what is now considered low risk, for instance, can be considered by certain communities or subjectivities like high risk for their lives. So just to give you an example, like you were saying, misgendering or using, for instance, of deep fake videos, exchange of material on social media. I mean, this can be all, for instance, I give you an example in the field of reproductive rights, for instance. There are apps that, I mean, can tell information regarding reproductive rights. It can be something very good. Think about countries where there can be a positive side, that where in countries where there are not a lot of access to certain information, they can provide with this app very useful. But what kind of information are there for which kind of people? Because you can give in this information misinformation. Because if they tackle, let's say, on the white woman with certain characteristics, it's not useful in certain communities. So you're not providing maybe the most important information. So this is an example to say that what's considered low risk can be highly risky in the impact for the person. So that's why it's important also the enforcement phase and the process also of litigation, in a sense, I mean, what there would be, the problem is that what about the damage that can be done in the meantime, that we're having enforcement, specifically unroll. We are still waiting on fundamental rights assessment, as Ian was saying, and we are waiting to put in place all these things. And there is something that I will touch upon later, but it's just current news. For us, it's very important. For instance, in Italy, yesterday there was the Senate passed a law, the first phase of the law on artificial intelligence, and they decided to have national authorities that's a governative authority. So we're not having an independent authority if they're going to approve this law as it is in the House, in the Parliament. So, I mean, there are big risks that we are talking about. So what guarantees, do we have in respect of, risk and assessment? Well, it's all confusing in a sense what agencies or we can rely upon, what enforcement or litigation tools. So we are still understanding what can we do, and in the meantime things are happening. And if you think about the use of AI by law enforcement in the public spaces, because police, for instance, has the opportunity to use the system, biometric law, whatever they want on us at the moment. So I give a provocation. I'm going to provoke a bit. You heard about the laws against pride in Hungary by Orban, unfortunately. So let's say that tomorrow the Italian government, Meloni, wants to do the same, and the police can use. They already, I give you as an activist, I protest for many topics, and all the time police is recording us, all the time, even for anti-fascist protests in our country, and they all the time are recording us. And I would like to say, why are you recording me? I'm in the street, I have an authorized protest. Why are you recording my face all the time? So why is that? So they can just come up and say, and record all of us and ban. I mean, that's why I'm saying we are not safe at the moment. And we are a step away of this kind of discrimination by, our law enforcement. They can record us, use our data, and maybe they want to show these images to your employer, and maybe you can feel threatened on your workplace if you keep continuing protesting on certain issues, and so on and so forth. We can keep discussing, so I don't want to be too long to call it to the others, but just to give you the practical field impact on our life as activists, but even as citizens that sometimes want to, fight for their rights.
Can I just quickly follow up that? Because I also think that the concept that AI Act is based on the product safety concept and fundamental rights, the combination doesn't really work properly, and it doesn't create this safety impression. And traditionally, product safety regulations were about more tangible products. So if you look around, probably most of the things around you are regulated. So if you go to the elevator, you trust the elevator that it will not fall because of the old technical specification. You don't have to know how the elevator works, but you trust in those in the elevator and technical documentation. So the EU legislators, they wanted to use the same concept. So what are the requirements that the AI system should meet that will be safe on the market? And then the fundamental rights are added on top of that. And I also think it wasn't the best approach, because the traditionally product safety regulation were about more tangible damages, and here we have more damages to fundamental rights, more intangible. Thank you.
Now that you say this example, sorry to say, my mom is afraid of escalators, the automatic escalators. Sorry to say, but in many places, there's no alternative to that system, you know. And she could say no, there should be another way. In a way, it's Mama, it's easier if you just follow. It's I don't want to follow, because I cannot do it, no. In a way, sorry to say that, but with the elevator thing, sometimes yeah, trust the elevator, but we forget that there are also some stairs that we could also take, and I think that in a way it seems that we are sort of being force fed by this idea that AI is the solution to our problems. No, when we keep seeing how technology is the solution and the problem to all our problems.
Thank you. I would like to move a bit to another topic, and I think the AI Act was conceived initially mostly having in mind the applications of automated decision making, allocative harms, and tasks like classification, ranking, search, and at the same time we had this really rapid and massive explosion of generative AI, which is a kind of different paradigm. Do you think it is sufficiently addressed within the AI Act? I mean, the kinds of harms that such systems could really bring?
Well, if the fundamental rights sound like an afterthought in the AI Act, the large language models or the ChatGPTs were indeed an afterthought. That's why they are in Article 50, and in this nice pyramid that we all love, they do not even know where to put it because, well, it doesn't really fit that well. What I want to say with this is this sort of irritating repetition to see transparency as the main solution to our problems. Somehow it seems that because there are different power asymmetries between different parties in different parts of the law, let's say in the employment context, the employer and the employee, they have different powers. They might be also having different kind of informations. So there has been this idea of seeing transparency as this tool to counterbalance those asymmetries. However, sometimes having this information provision mindset or way of transparency does not really solve the solution, or does not really solve the problem. No, you can provide information that may prime seeing over understanding. If you remember Las Meninas de Velázquez, it's this very beautiful painting, in which there's the Meninas, and that she has a dog, and so the painting was not really that. The painting was Velázquez painting the couple that is reflected into the mirror, in the other side. Just quick art example, which I love art, but just to show that not because you're seeing something, it means that you are understanding, And the AI Act is very insistive in providing information about many things, In the case of the high-risk systems, there is a very specific list of things that they needs to be said, mirroring a little bit like the GDPR idea, like on providing information about the company, the intended purpose, the accuracy, etc. When it comes to generative or general purpose things, it's not that it's not that clear that providing that information is actually going to be enough sometimes, like to solve some of the problems that they are going to have, especially like because of what you were saying, no, that not because a system it is categorized as such, it means that it reflects truly the impact that it's having in certain communities. And I see a real danger in leaving to someone, which I do not really understand who. In this case, I think that it's like the companies to determine what is the risk level that their solutions are going to pose to certain communities, because they are not in position to know that. So it makes a little bit no sense to me.
Very nice. As I said, if there is any question from the audience, please, yes.
Now, just a quick reaction on what just has been said. I mean, transparency is not something that will resolve the issue. If there's discrimination, there's discrimination. It's not because we have transparency that the discrimination does not exist. But it is a way to see what is going on. And I'll give you one simple example. At the EU level, we have a directive that was adopted on gender equality, and it's called Pay Transparency Directive. We know that if we show our pay as men or women, it doesn't mean that women and men will earn the same thing. But pay secrecy is one of the main barriers to access to gender equality or pay equality. And this is why also we think that transparency is still a good moderator. Because first of all, employers has to be transparent on and say what are the information, like let's say what is the data that is collected, how it's used, where it's used, etc. So at least we can see if there's an issue or not. But of course, if there's an issue and then if there's no law, then nothing will happen. But if we can see that discrimination is a big risk there, then we might try to avoid this and, I don't know, try to find the solutions. And of course, when it comes to the workplace level, I pretty much believe that it should be a dialogue also between the employers and the workers, because no one external from the company knows exactly how things work in the company, how the work organization is done, and what is the impact of these tools on the work organization itself. So it has to have an impact. We can make any legislation at the EU level or at national level. If we don't try to adapt it the best way it is at the workplace and to answer the work organization's challenges, then it will not work. So this is why our opinion is that transparency is a way to open this discussion and to try to find the best appropriate measures to prevent these risks.
Can I follow up with,
Sure.
with this? Yes, I also think that transparency is like not the holy grail here, but it's important, and we can refer to the recent case of the Court of Justice of the European Union. But this is the case based on a GDPR case done in Brand Street, and this is the case about AI and arose when the individual was denied for a mobile contract, and those denial was based on AI system that assess the credit worthiness of this individual. And the CJEU, it's a recent case, ruled that cases involving automated decision-making should be transparent, should be easily, the explanation should be really easy to access and concise. So by those means, I think GDPR can help with, and with combination with transparency, because if the company cannot show how they came up with the decision, then probably the decision is not valid for this individual. So I agree that it's not the transparency is not enough, but it can be with connection to also to data protection law can be a way to protect individuals.
Very quick comment that I agree with Nina, transparency is very important, but then as, let's say, an activist point of view, even if something introspect, I'm talking generally, not the example on the workplace that I totally agree, just by giving information. For instance, I told you before separately, share with everyone here that, for instance, we are working with trade unions in Italy and asking them to map the use of AI system in companies. So because we should know what they're using it for, so I absolutely agree. But on the other hand, I've seen as an activist that when you request some data that can be open or transparent, the issue is that what you do with it. So transparency is not enough, because if you don't have the skills to use that information, to read them, analyze them, and enforce them, what do you do with them? So the problem is that also, you know, like empowering and make people give the tools to use the information they can gather to mobilize and use them for their rights. That's the other tricky part.
I'll add something it's probably a very small tweak to what you just said, which is that you need to think about how there's an additional step there about how transparent, you know, data that's provided for transparency is presented and shared, and sort of the nature in which it's shared. So is it made accessible? Is it deliberately made obtuse so that, you know, a company can say they fulfilled their transparency obligation without providing meaningful transparency? You know, what kind of user interaction work is done? So I think, you know, particularly a lot of some kind of HCI work or UX work about data transparency for literacy and making it legible and making it literate to wide range of stakeholders, particularly those without, you know, data science skills, rather than it being almost weaponized in an obfuscatory approach.
Yeah, and also to respond to this, in a way, it's not one thing or another one. No, I really like the meaningful transparency. For me, just being transparent about the pay gap is not enough. It's great, thank you, but make the gap disappear, no? Like, I mean, yeah, it is just like, in a way, it is a very limited understanding of how are we going to solve that problem. And because companies, how they really work with lawyers that tell us, well, within the liberty space that the law provides us, what can we do? And they have amazing lawyers that they are really saying like how they can comply with the legislation and get away with what they want. Like, I mean, we even have, like, in the lawyer mindset, like, have you seen like Get Away with Murder? Like, I mean, we do that. Like, that's why it's a terrible profession. But what I'm saying with this is that in a way that is the expectation that you have, and that is why somehow you already will have. And I would have imagined that in 2025, we would know that, well, yes, it takes time to get a European agreement on a text, but we would have already understood that being cautious about certain things will lead to many problems, because already like lawyers and legal advisors are really taking advantage of those parts in order to then make compliance checklist, or really going a little bit beyond of what we try to do, like in some of these European projects that we have to really like try to change the narrative, try to change the culture. If we then see that our frameworks are already somehow perpetuating certain biases because of the way they are written, no? Yeah, transparency is great, but then it likes operationalization. Then, yeah, gender, it is there reflected, but then it is not that much, explained, no? Or like then intersectionality, like it is not accounted for, no? Or then there are like these list of discriminatory grounds, and it seems that if you are away from those, then it's not. And then we keep seeing, oh, then this new race of words, the bias, and then toxicity, and then it's like, well, but is this legal or illegal? No, like, because for a lawyer, at the end of the day, it's like, well, we had a word called discrimination, which already explained clearly what we wanted to prohibit, because that is what we always say, that is not an issue to discuss, it's a problem to solve, that it is the illegality, no? So just like to say that, so like the remark is that it's a great first step, but then we need more, no? And for me, the problem is that when we are looking at the structure of the regulation, that is a very boring discussion, but if you look at it, is years ago in the new legislative framework, which is of course not new anymore, the European legislator understood that didn't have the time to further elaborate on several topics. So the idea of a lot of these legislations within that framework was to say, I'm going to develop a framework, and then it is going to be companies and standardization activities or bodies that they are going to further develop those principles. That worked extremely well. Like, let's not trash everything. Like a USB-C, like I don't know, like how much we gained against like the Apples and their cables, and so like a lot of the work that it is being conducted in the standardization, it's great. Like they have the know-how, and so it's just that it's not very representative. The way these committees are working, they work for a fee. So if you don't pay the fee, you're not part of the table. Academics, we get a discount. Thank you so much. We are from social sciences, so we're like extremely poor too. So like the access to that is it's a joke. And then and then when it comes to this mandate, like that now the European with the AI Act, they're really trying to push for standardization on the one side, and then also for effective, they call it effective stakeholder engagement. Tell me how, really. Like, tell me how, if all of the standardization activities, they are private, that then companies, they have a dedicated personnel, that they are there every day, you know? Like, when you are, like, as a scholar, sorry for my language, but, like, they make you feel like shit, you know? Like, because you're trying to deal with the exams of the students, your presentations, your projects, and so, and then you're there at the European Commission trying to make your point, and then you have, like, these people, it's discouraging to the max. So in a way, yes, you would say we need to have these voices there, but the community is tired. Like, I mean, I really admire like the activists. Like, but in many occasions, it's a bit, and I use again the word irritating truth. No, that those that they are in this asymmetrical or imbalanced position, then they even have this duty to get up and go and fight and don't get tired and keep pushing and go and go and go. And that is, it's something that you would say, well, if we could have created the structure in which we could then have those voices there heard as a default, instead of like this continuous battle, like, oh, it would make life a bit easier, I would say.
Wanky, and even unpaid to do so. Sorry, I want to point out something. It's not only even unpaid, on voluntary work, on your expenses, to go to Brussels, whatever. So, and one quick thing about, besides the unpaid issue, that's an important issue, for the standardization, that what I was saying about national authorities would be very troubling, because how can you standardize if every country in Europe would have to apply the enforcement of AI Act? So if we have 27 countries, each one of them has a different national authority that works in different way, how we can guarantee, you know, equality even among our countries, you know what I mean, of rights. So that's another big issue that I think we should mention that's really at stake. I think it's ethically terrible that maybe I'm more protective than a person in, I don't mention countries, otherwise it seems prejudicial, in any other European countries, or actually the contrary, you know, a French or Spanish person is more protected than me as an Italian. I do the contrary, that's most likely, given our current state of government issue. But that's really troubling. It's one of the, I believe it's one of the main risks that we are facing.
Thank you. Two small but not so small issues that I wanted to ask about is one about how intersectionality is addressed by AI Act, and the second one, how what is the interplay between AI Act and GDPR and data protection. Maybe Nina, you'd like to?
The short answer would be intersectionality is not regulated in the AI Act, and I could finish here. But intersectionality is generally like a big problem, like the practical problem. So it exists when there is like two characteristics at the same time, and those characteristics are inseparable. So for example, in intersectional discrimination happens and affects migrant women or gay people with disability. So there is always like two or more characteristics, and they create this kind of the synergy. The problem is, first of all, in the AI Act, it's not regulated, but it's also not regulated in really non-discrimination law. It's traditionally non-discrimination law is based on one protected characteristic. So we have to prove that we were discriminated against, for example, ethnicity or gender. So it's like more separate. And with the AI systems, it's like even more burning problems because the system can make many correlations and have much more information about individuals. To be honest, like intersectional discrimination is like even at the EU level, there is a resolution of the Parliament, but then the Court of Justice of the European Union kind of denied intersectional discrimination. In the national laws, we have some cases, but the concept is not really well developed. In France, there was a case with trade union and disability intersectional, but it's not really like a full concept that the individual can rely on, I would say like generally discrimination cases in law are very hard to prove. Like first of all, people have to know that they are discriminated, which is the case that sometimes they don't know. And then going to the court is like another step. So there are not many cases that they are reaching the point to go to the court. The court proceedings are costly, are long, they are time consuming, and so not many cases are even reaching the point to go to the court. And with intersectionality, it's even more complicated. And I'm trying to, now I will try to say something positive because our panel is getting very depressing. Maybe I'm too optimistic, but intersectionality is like a more practical problem. So maybe if we have some technical solutions to detect intersectional discrimination, because if you can think about those, maybe that can we act proactively, because the protection after, it's like really blurred, to be honest. So it's I think it's still an area worth to explore, and probably if we have some tools to show intersectional discrimination, then maybe even before the court, maybe there will be more cases, so people will have some proofs to go there. So far, it's really unexplored area, and judges are quite not really willing to dive into.
Yeah, thanks a lot, Nina. Just a quick comment to give a silver line. What I see as a positive side is that at least with AI, maybe some of the issues that we are talking about are more clear. Because, I mean, now we're talking about ethic of AI, but ethic of society. I mean, it seems like we're expecting from AI something that we are not pretending from our institution at any level, or our companies at any level. It's because AI is involved, there should be ethical, everything, you know? That's good, but the problem is at the base, even without the technology. So maybe the silver line is that it's so exponential and powerful, this technology, that polarizes all the bad things that we are having in our society. At least we can say we can use it, as Nina said very well, to, you know, point it out on the other problem without the technology that create the situation for these big inequalities and discrimination. So I think that can be the silver line of all of that.
Very nice. And Nina, do you also have something to say about the interplay between AI Act and data protection?
Yeah, so this is a big topic, quite legal and quite nerdy, I think. So first of all, like as I said, the AI Act doesn't exist in the isolation, and it's really related to non-discrimination law, and of course to GDPR when it comes to processing personal data. Also important to know that the AI Act does not change GDPR, and I think GDPR still plays a role here for protecting individuals, and the GDPR gives like more power to protect rights of individuals. And there is this very important relation between the AI Act and the GDPR that relates to sensitive data. One remark is like when I talk about sensitive data, I mean sensitive data by GDPR, so it's like special categories of personal data. So it's not the same as sensitive attributes that are used in computer science because, for example, gender and age are not perceived as sensitive data based on GDPR. There are just personal data. And then, so sensitive data, they overlap with those characteristics that are protected under non-discrimination law. And what is important that when we already have an AI product, AI system on the market, let's say our ranking system that we are working in FINDHR, and the company wants to monitor this system, so for potential discrimination, then let's say discrimination against ethnicity, then the company needs to know the ethnicity of job applicants. And in principle, like GDPR prohibits the use of sensitive data, and if you think about it, it does it for a good reason, because those information are very sensitive in a way. It's like ethnicity, religion, sex life, sexual orientation. It also covers inferred data. So, for example, the name of the partner can reveal a sexual orientation. So it's like the protection. I mean, it's justified. But so GDPR prohibits that. There are some exceptions. So, for example, explicit and freely given consent. If there is explicit and freely given consent, then the company could use that. Then we have substantial public interest and specific regulation, and that was the case in the Northern Ireland that Lynette was talking about. So we're asking for a community background, so being Protestant or Catholic was based on the regulation there, on the legal act. So that's the exception. And also the AI Act like clarifies this exception or a substantial public interest, and it allows providers to process sensitive personal data when this processing is strictly necessary to detect and correct bias, but only in training, validation, and testing data sets. So basically during the development stage. There is also a list of safeguards. So first the company should use synthetic data, but it's still development stage. So when the
sorry, Nina, is the same applicable also for auditing of such systems? So they have strictly access to such kinds of data and not to actual?
Yeah.
Okay.
So basically when the company wants to monitor the system when the system is running, they cannot rely on this exception. So what we have left is a consent. The consent should be explicit in that sense, as it should be voluntary, should be freely given. And here we are getting into the gray area because, for example, in some sectors, as unemployment is one of those sectors, when we have the situation when there is a power imbalance, then the consent, a European Data Protection Board, in their guidelines, they said that in those situations, consent of the person, so of the employee, of the job applicant, cannot be really, it's not likely that it will be freely given. And of course, of the fear of having the negative effects and all this risk that so people might feel forced to give the consent in those a power imbalance situation. Also this is the case that we are dealing in FINDHR, and what is like quite disturbing to me that also Roger said that also we have this in our participatory action research results that people tend to change their names, change to their kind of identity to get a job. So they are in the situation that the consent is cannot be really freely given. And basically, the use of sensitive data for monitoring a system after it's deployed is complex, is complicated. In FINDHR, we are working on trusted third-party computation. So there is like another third party, and the consent is given to this third party. So to skip this power imbalance, but this is like one of the solutions. And maybe like my general remark about GDPR would be that GDPR has really individualistic perspective to personal data. It's based on a notice and consent. It's not the best idea. There is a lot of criticism around this. And processing personal data for detecting or mitigating bias for me looks like a checklist a little bit, so like more like a technical issue. Okay, we have to check bias detection done. Okay, we are good to go. So it doesn't really capture this like whole complexity about bias detection and mitigation.
I have a naive question. There's going to be thousands, hundreds of thousands of AI systems deployed in a variety of applications. And judging by the conversation, it seems extremely complicated to audit and monitor these systems. How are we supposed to enforce the AI Act, and what will happen in practice? I mean, what's your feeling about the practical implementation?
That's a lawyer. Sorry, yeah, cheers. So I think this issue, once again, highlights some of the antagonism between lawyers and technologists. I think a lot of, but obviously the issue I think we're facing, particularly in our project and in general, is that it's still very inchoate what the AI looks like, because so much of the burden of the act is actually put on the enforcement and compliance measures and the regime, and it's very much an emergent regime. You know, there's additional provisions scheduled in August of this year for what the compliance regime will be like, and I think from what I recall, everything until August 2026, except for the high-risk compliance, which comes into effect in August 2027. So we don't actually know, and we're having to do best guess without actually understanding. So this is the first problem. The second issue, I think a lot of the heavy lifting for compliance is being put onto the technological approaches and the solutions. And one way in which this is being done is through standards bodies. So particularly the European Commission has tasked CEN-CENELEC, which is the European Standards Body Joint Committee 21, to basically establish guidelines in what's relevant to us are for AI fairness. And the problem, as we've ascertained throughout this, the last 2 days, is every application of fairness is very dependent on a context and the, horses for courses right solution to that context. And so to have a standard, the point is a standard is supposed to be general and broadly applicable. So it's not actually going to give specific technical guidance on how to manage the, each specific use case. It's just not viable or possible, especially considering, like you said, the, tens of thousands of systems and the tens of thousands of contexts. And a lot of pressure is being put on the standards committees, and it's almost this buck passing, right? And so they'll give general guidelines, but it's not actually going to solve the technical problems. And what you actually find, and I think this is kind of what we've encountered, at the coalface, trying to, do a proto version of this work in Mammoth, like we said, without actually having guidelines what compliance is going to look like, is that between lawyers, social scientists, and technologists like myself and the technicians, there are very different epistemologies at work, right? You need I think one of our key messages is you need multidisciplinary stakeholder engagement, but how we see the world, how we, is very different from how a lawyer interprets the world and the lawyer interprets provisions, from how a technologist, actually has to instantiate these into mathematical principles and code, right? And it's a very complex problem of translation. It's very messy, and you're dealing with almost, mathematics is very much based on rules and logics, whereas I'd say, you're dealing with very fuzzy concepts, from a social science perspective at least, you're dealing with very fuzzy concepts like subjectivity and power relations. They're very abstract, hard to pin down and define concepts, whereas a lawyer is going to deal with, does it fit this definition? Does the definition adhere to this principle? Does this relate to, what's happening in case law? And I think there's a lot of this translation work that needs to be done, and it's not easy, and it's really hard to actually see what the end goal of implementation. What I'm concerned almost is you're going to get this buck passing around of, oh, well, it's down to the implementation by the technologists. Well, the technologists are like, we can't solve this problem. It's just not a technological problem. Then it goes back to social scientists try and solve, and then it goes back to the lawyers, right? And so, yeah, I think this is going to be a key challenge.
I wanted to say that in a practical note, the AI Act is going to also put in place different databases for high-risk applications. So Article 60 mentions that providers of high-risk systems need to register their system in a central European database before placing it into the market. And they need to give information about the provider name and the contact, the description of the system and its intended purpose, as well as the conformity assessment results and the post-marketing monitoring reports. And this is managed by the European Commission. And in theory, it is going to be accessible by the public, and that it is in order to increase accountability and transparency. And there will be a special registry for general purpose models ones. And what I wanted to say is that the enforcement, in theory, it is a little bit multi-layered. It is true what Giulia also mentioned before, that, well, there are going to be different national authorities that are going to survey this. I think that Spain is the first one that created one in Galicia, I think, but that also is a bit government-based and so. And yeah, when looking at the profiles of the people that they have been appointed to that, well, I will not comment.
Not
but but yeah, like it's once more like what we were saying before. Like, it's a missed opportunity to make something good, like it's like, oh, we're going to have an agency, like, why don't we do something modern and progressive and forward looking? So there will be like the national surveillance authorities, and then there's going to be, or there is already, like European Artificial Intelligence Office. It's a little bit of yeah, there also it sounds not that serious in the sense that it is part of the DG Connect. So financially talking, it's part of an already existing unit. So it creates a little bit of a burden of an already existing institution. So it's not that they're like allocated funds on that. And then there will be like what they call the European Artificial Intelligence Board, which it may have a little bit of a function similar to the European Data Protection Board. Just to say on that, there are also penalties up to 35 million and also 7% of the global turnover. So like the penalties are scary, I would say. But then, well, given the how much time it took also like for the GDPR like to be in a way up and running also in the enforcement level, we will have to wait and see.
Mm-hmm.
A very quick comment. I go back again to the national authorities. A brief coming out. I talk a lot about national authorities because we are part of a coalition in Italy. It's a network for digital human rights. So we are a 7-8 association. We work nationally to this topic, so we gather together as activists to be stronger and have one voice to advocate for this issue. One of the issues we were advocating for independent national authorities. And there are other issues, but now I'll just stick to the national authorities. I want to point out another factor, like you said, Akis, that there would be hundreds of thousands of AI systems. The issue is also economic. I mean, how much infrastructure and economic resources does these national authorities have to be effective? Because we come again to the thing that's not only about the values, but it's also about the money. So if certain countries don't invest more economic resources, we risk that we'll not be able to monitor, even if they have the best intentions. And so we risk a lot of imbalances, given how much economic investment you do on your national authorities. They will have enough money, because we risk to have a formal national authority that does stuff, but it's not really effective because it doesn't have the infrastructure, the economic resources, personal staff, whatever they need to do their job. So we risk to have an empty box, basically.
The money is going to be in defense and not in this. It's a joke.
Yeah.
Very nice. As we are heading almost towards the end of the panel, I have one last question, but I would like to give a last opportunity to people here if they do have something to... Yes, please.
Thank you. I agree with a lot of what you said, but also to say let's try not to be too depressing, positive. Yeah, it's extremely limited, the AI Act and GDPR. I'm not a huge fan of either, but it is an effort, you know, and coming from a technology background, no one I know cares about this. Like, it's really nice to be in a room of people who care. It's just like, it's full forward, let's build stuff, never mind the consequences because it'll all work out. So for me, the AI Act is a chance, even if it doesn't work, right, and it can't be enforced. It's trying to change the culture of it's not enough just to build something. You need to think about it. And even if they pay the 35 million, they say, okay, that's an acceptable cost because we're making so much more than that. It is like, well done us. You know, I just like to make that comment for trying to do something, for trying to change the culture. And it will take time, but we've got to try to rein it in all of the ways that you're doing it. So I just wanted to say thank you and carry on, and you know, you can do it.
Yeah, I guess that what we're trying to say here is that, yeah, it's nice, but when that does not represent you, it hurts. And on the contrary, it's going to establish a narrative, and it's going to establish like a standard, and people will take it from here. Like now, revising this, it's really not possible in a way, like because it was already in 2021. Like all of these like comes like already in 2017, civil law rules of robotics, then digital strategy in 18, then high-level expert group on AI, and then AI Act proposal 2021, now the formal text 2024. There's so many things, no? Like it is really, I have a colleague in Torino called Marco Giraudo. He talks about legal bubbles. It's really a bubble, like, and we risk that this bubble gets burst at some point because there is this normative, like folie normative, no? Like this sort of folie normative, like a crazy legal response, like in a way, like it really comes as a sort of a response to this battle against, or like because of the innovation, and then because in Europe we see regulation as an enabler, and we really do see the value in that. Then it seems that the AI Act seemed like the logical consequent step towards enabling that and ensuring fundamental rights. But the research was there, and it's not the first time that activists are there and highlighting these issues. It's not that that we haven't been saying this before, no? Like, so in a way, yeah, it's nice, but then it's like, oh, but there's so many competent people and so many research and so many things that we have done that could have been there. It is just that it's everything left to this political power. Everything seems like very like cherry picked, you know, like, oh, high risk categories, like look at these ones. Oh, there's this scandal in the UK like about education. Oh, that sounds like something that needs to be in the regulation. And then and it's like, is this serious? Like, you know, in a way that is the impression like that sometimes we feel like, especially when you ask people and how you feel, like, do you feel like you're talking about safety? And you're talking about your own safety. Like, let me tell you, the product safety rationale behind this regulation, it's not about human safety. Like, it's about whether the system is about the elevator, you know, like, and that is really, I don't know, like it worries me when I hear this does not make me feel safe. On the contrary, like, this is like, it's alerting you that this is causing fundamental problems. So it's not that I don't want, or like that I want to say this is in a negative note. It is just that this is not well done, and it could have been done better because we do have the structure, we have the knowledge, like we do have this. Like, what is this? Like, yeah, sorry, just that.
Yes.
I think I might provide a more positive counterpoint. I want to thank you for raising that point, actually. And I think you're right. It is a statement of intent by the EU, and I think it does shift the culture, as you know we have seen in GDPR. It has forced a global culture shift, and particularly considering the kind of current, you know, Trumpian anti-regulation zeitgeist. And I don't think there necessarily needs to be this antagonism between the AI Act. It doesn't do enough, but you need to do something productive and build, right, rather than just criticize. And I think what the AI Act does, it at least gives breaks, right? It gives a bare minimum set of safety standards, but then ethical approaches can build on that. And I don't think there is necessarily this antagonism between these approaches. And I think sometimes you have to not just fight, argue, criticize, but you also have to negotiate and make things work and engage in a proactive process. And I think if we look at the AI Act as a basis for a responsible innovation approach, right? Let's say the Volvo approach, right? Where safety, better ethical compliance becomes a unique selling point, right? We're not just getting the cheapest, crappiest, system we can get away with, but it actually makes a better, safer system. You'll get buy-in from industry, you'll get buy-in from individuals, and I know there's a lot of criticism, particularly from activist circles, about CSR approaches, but they do have a certain soft power, and I think if you can, rather than shouting at stakeholders, getting everyone on board and working together towards these goals, I think that is a positive, and I think if done correctly, I think the AI Act can do that, both in providing security, for affected individuals, but also being a way for European companies and hopefully, companies elsewhere to, do better design, actually foreground ethics in design, and then, make that a positive for them and make it a selling point. I don't necessarily think that there needs to be this antagonism.
I try to combine this, like both critique and these positive aspects, and I recently heard the term pracademic, so this is an academic and practitioner at the same time, and if we look from academic side or activist side, yes, I think we have a full right to criticize the AI Act. I think that was also like a missed opportunity to regulate it in a better way, and it's our obligation as researcher, as activists, to really point out the weaknesses, but also from the practical side and as a practitioner, I mean, the AI Act is here and we have to deal with it. It's not going to be changed really soon. Probably there will be more delegated acts, but we have to somehow comply. We have to find a way to make it better in applications.
I make a joke. I'm going to confirm the stereotype that feminists sometimes are killjoy, so I'm going to killjoy again by saying, because I think it's very ethically important to say one thing. I agree with everything you said, all of you, but I think we should point out, even if it would be the best regulation we have, there is still a main problem behind it that is just for European citizens. I mean, a migrant person coming to Europe, it's not protected. You can get all the biometrics of them. So it still it's a human issue, I mean, it's an ethical issue. We should not be okay with it just because only certain people are protected by it and others.
Inherently discriminating.
Yes.
Okay.
Actually, we haven't said that, so I think it's important we point it out, and we should refuse it just because it's not protecting every human being in the European territory by this regulation. Because migrants coming, you know, for Italians, fortunately, we have this Mediterranean that became a huge cemetery as a sea. It's not a sea anymore. It's just a cemetery. People die there. It's a big issue. So we can get whatever biometrics of them. You know, you heard about what our Prime Minister did with the Albania deportation center. I mean, it's all fucked up. Sorry for the French, but that's something we should not even accept, even if it's the best regulation, which, as I said, it's not. It's ethically wrong because just protects certain human beings compared to others. So we should fight anyhow just for this reason. That's very unfair.
Thank you for this closing remark. Sorry. No worries. We are in favor of inclusion and any kind of language anyway. So yes, I really would like to thank you because now I feel more prepared to enter the AI Act era. I feel also a bit more concerned, to be honest. Yes, I would like to thank all of you, and I would like to invite also people to give an applause.
So we're gonna wrap up. I wrote some notes throughout the day. So as closing remarks, today in the morning we heard that cases like Compass start to feel like the good old days where things were simpler a few years ago, and I guess many of us got interested in this because of those simpler cases that now feel like very dated, like classics. We have a much better understanding of tools and metrics for fairness, and this we saw yesterday in the workshop. I think there is an increased engagement with trade unions and with NGOs. We have seen a lot of that, and I'm very happy to see that because it's very difficult to achieve. And there is, we spoke about the necessity and also huge challenges around sensitive data collection. Recruitment is a central topic to two of the projects, but it appears in the other two projects too. So I think that's interesting. And generative AI is becoming increasingly another scenario that is important. We heard a wonderful panel about regulation that is very key, but it's also yet to mature, and it will take several years for things to arrive to the point where things are applicable. And I would say that the glass is half empty and half full, and we keep working. I don't know if you have anything. Okay, and thanks for coming.
Yes, that was a great summary. Yes, we hope we can resume again in a few months or in a year.
Yeah, shall we say, okay, we're going to say something, we're not sure, but we're kind of sure.
But in October we do have a Brussels event, yes.
Okay, so we will meet again in Brussels in October, or we won't, okay? Okay, because we haven't anything like set in stone, but most likely.
But we have the 14th and the 15th of October set already, so you can mark it in your calendar.
Yeah, you can pencil that in your calendar, 14th and 15th of October.
Yes. Okay, thank you everyone for coming.
Thank you.